If you were arrested, but you have not been to court yet in Los Angeles or Orange County, this video is for you because I'm going to be sharing with you information that you probably don't have that could save you a criminal record, jail time, huge fines, a lot of worry and stress and heartbreak. So let's get right into it. My name is Veronica. I am a criminal defense attorney here in Los Angeles, and I help people who have been arrested put their criminal cases behind them so that they can enjoy their lives and their freedom. And again, in this video, we're going to be talking about the one thing that you need to know and really that you need to do if you were arrested, bonded out, and have not been to court yet. Okay, so if you were arrested, you're given a court date, right? You're told you bond out, or maybe you're given a citation. And when I say arrested, sometimes you're given a citation and you don't actually have to post bond, so you weren't actually handcuffed. But it's technically an arrest, so you're given usually like a yellow or pink slip citation, or you go to jail, you bond out, and then your bail bondsman probably impresses upon you and makes you sign in 3 places, hey, here's your court date, make sure that you show up for it. Now you have a court date, right? And you probably, hopefully, have put that on your calendar and you're thinking, okay, there's a criminal case against me. Some people have even called me and they say, I have a felony, and all they have is they were arrested for a felony and now they have a court date. So what you might not know, because it's not intuitive whatsoever, is that criminal charges probably have not been filed against you yet. So how this all works is you get arrested, right? The police generate a police report. You get arrested or cited. Police generate a police report. You're given a court date, and that's put on the court calendar, kind of. But in the meantime, that police report has to be given to the prosecution. And it is the prosecution, not the police, that actually files charges against you. Why is all this important? Why do I care about this? Maybe you're about to click over to the next YouTube video. Okay, but this is the important part. So what that means is that in this period of time, between the time that you get out, really between your arrest and the first court date, you have a golden window of opportunity to get to the prosecution, have an attorney talk to them, and try to get them to not file the case. What would make them not file the case? Well, so first of all, they're going to be looking at the police report, right? So the police report generally is not going to be good for you. The police want to justify the arrest that they made. They don't want to make it seem like they arrested somebody for no reason. So what would make them not file is potentially seeing your side of the story. That's one thing. Your attorney can talk to the prosecutor, can submit a letter on your behalf explaining your side of it. There can be letters of recommendation, a letter that explains what a good person you are, all the volunteer work you do, all the good things about you, all the things when you're thinking, man, I don't deserve this. I don't deserve a felony. I don't deserve to go to jail or a misdemeanor, whatever it is. That is explained by an attorney ahead of time. Also, sometimes there are problems with the case. Sometimes there was an illegal search. And so what you want the prosecutor to be thinking about when they're thinking, do I file this case or not? Because think about how many arrests there are. Think about how many people are arrested and there's no evidence. They can't file all of those cases, and they don't. So when the prosecutor's looking at this, they're thinking, if there's a problem with an illegal search, or if you weren't read your rights and the main evidence that they have against you is a confession and you were in custody being interrogated, there are rules on it. But if an attorney can convince the DA, hey, if you guys file this case, I'm going to get it dropped. Or maybe the attorney, especially in LA County, Orange County, it's very busy, a lot of crime, can convince the DA, hey, look, my client just had a really bad night. This is one really bad incident that happened. Not exactly what the police are saying, but this is somebody who is a hardworking person, a good person, maybe somebody who's had some hardships along the way, but someone who deserves a second chance. And that may sound kind of stupid here, right? Like, we're dealing with the police, we're dealing with the justice system. They're not doing it to be nice. They're doing it because they want to get the worst of the worst. So if your attorney can show them, hey, this person's not worth prosecuting. If you see my client back here within the time before the statute of limitations runs out, then fine, file. But this was a one-time thing that's never going to happen again. Give him or her a second chance. That is how you can get these charges dropped. Now, why all of this is important is because many times, especially if you had to spend money on bond, or it is hard in the world right now. The economy is not the best. Sometimes you have limited resources and you may be thinking, you know what, I'm just going to wait to hire an attorney. I'll see what happens. I'll go to my court date. Maybe you heard, oh, you know what, maybe they'll drop it down or maybe they won't file. The thing is, that's true in some cases. That is true. You know, the DA is looking at this and they're deciding whether or not to file. If you don't do anything, they'll just look at the police report and decide. But your story isn't probably in the police report, not what you told them, even if you talked to them. The good things, your side of the case it's not in the police report as a defendant, as somebody who is arrested. So if you wait, you miss that chance. So if they file as a felony, it is a lot more difficult to later get them to drop it down to a misdemeanor than it is at the very beginning. You know, once they file in court, they assign a felony DA to the case, or, you know, misdemeanor too. They assign a DA who now is like, hey, I have this stack of cases. I want to win these cases. That's a much different calculation that person is making than somebody who has a big stack of police reports. They're looking at them really quickly and they're trying to decide, do I file this one or not? Now, you probably want to be that one on that big stack of hundreds of police reports that actually has, oh, here's some letters of recommendation for him. Here is, you know, his employment history. Here's a letter from the alleged victim explaining what actually happened and that they never wanted any kind of arrest to occur. Whatever it may be, you probably want to be one of those few that actually has that ready to go. You know, one of the people where you have an attorney that's calling the office ahead of time. So I would actually recommend, if you're trying to figure out, okay, I have limited resources here, should I wait or should I just hire an attorney now? I actually think, depending on the case, if it's like a first-time domestic violence, then yes. If it's a case like that there's already a decent shot that they might not file, I would hire an attorney before the first court date. If they file, okay, first of all, maybe now they file as a misdemeanor instead of a felony. But if they file, okay, now maybe you use the public defender. Maybe that first attorney gives you a deal or doesn't charge you much more or anything at all to represent you in the case, if you've already retained them ahead of time. But you haven't missed that golden window of opportunity. And I handle cases like this all the time where we are able to get them to drop it. Now, it's hard to say, okay, without my involvement in some of those cases, maybe they wouldn't have filed it anyway. And I tell my clients that, hey, look, in this case, I think for XYZ reason, you have a decent shot at them not filing. But if it were me, I for sure, especially because I want to protect my record, right? As an attorney, I'm going to have to answer to the state bar if I have anything on my record, if I get charged with a crime. I would want to give that first part the best shot possible. In the meantime, you know, I would probably be hustling, saving my money, so if down the road I need it later, I will have it. But, you know, if I had to choose one or the other, in a case that's like a first-time domestic violence, first-time low-level felony, misdemeanor, or maybe I have some old criminal history, but it really doesn't have anything to do with what I'm being accused of here. In LA and in Orange County, I would absolutely want to at least talk to attorneys beforehand and figure out if this is something that I should be doing. Hiring an attorney to contact the DA before court and try to get the whole thing dropped. Because if it's dropped, you're done, right? You're done with the whole thing. It's actually better than going to trial and winning because the whole case is totally over. You don't have to worry about that stress. It's much less expensive. It is absolutely, in first-time cases, especially domestic violence, it is absolutely your very best shot at getting the whole thing over with quickly and cheaply. So I hope that helped. If you do have any questions and you have a case in Los Angeles or Orange County, feel free to give me a call. My number's down below. You can also book a consultation with me there.